This is Attorney Timothy Crawford, and I'm going to be talking to you about the use of trust in estate planning. We have other videos that you can look at that talk about the individual parts of trust and when they're used, such as to avoid the probate process. But in this video, we're going to combine a discussion on trust. They're many times referred to as living trust because they're set up while you're alive. They're actually have assets put into them while you are alive. And they are revocable trust. They are used for estate planning. There are other types of trust that are used for other reasons. The most common one is asset protection planning, where you would use an irrevocable trust. Very important to remember the distinction between revocable and irrevocable trust. But today we're talking about revocable trust used for estate planning. They're used as a substitute for a will. They direct who's going to get your money when you die. But you put your assets into it during lifetime so that at death you do not have an asset that has to go through probate court to be retitled. You get to use the asset. It's yours. It just happens to be inside your trust. You're the manager of the trust. We call that person the trustee. You are the person who started the trust. We call that person the grantor. You are the person that has a right to use all of the assets inside the trust. We call that person a beneficiary. You are wearing all three hats. For tax purposes, the government just totally ignores the trust, and you just continue to report everything like you used to do on your personal tax return. But the beauty of the trust is it can be used to minimize death taxes. However, as we taught you on a previous video, you don't have to worry about death taxes. Okay? You don't have to worry about gift taxes. So the trust you're using here is really being used again as a substitute for a will. We encourage you to study and see if the living trust is the appropriate document for you to use. Not everybody needs a living trust, but everybody should avoid the probate process. So you don't want to die with just a will. You want to make sure you're avoiding the probate process. And we have other videos that discuss how to avoid the probate process with a transfer on death deed or a will substitute agreement for those of you living in Wisconsin, or for those of you that at the time of your death have only $50,000 or less in assets in your name alone that don't have a beneficiary designation on it. With those, you can avoid probate. Again, look to my special videos on each of those topics for a short discussion about that. But again, I encourage you to look at the use of a living trust package, because what it can do is wonderful things for you that some of the other probate avoidance devices cannot do, such as holding money back from young grandchildren who you may not want to have get money outright, and you want to have it slowly given to them so that they will still have money left for important things like college education, starting a business, buying their first home. Again, lots of information can be found at my website on the use of revocable living trust. Again, you can find that at tpclaw.com. Stands for Attorney Timothy P. Crawford. I thank you for watching.